Most people find out the hard way. The flashing lights appear in the rearview mirror, and suddenly that firearm you legally owned 5 minutes ago becomes a criminal charge. Not because you did anything wrong, but because you crossed an invisible line that nobody ever told you existed. Here's what makes this so frustrating. There are gun rights specifically designed for Americans over 60 that could save you thousands of dollars, keep you out of legal trouble, and protect freedoms you didn't even know you were losing. But here's the catch. The system doesn't advertise these protections. In fact, it profits when you don't know about them. Today, we're exposing 10 of these hidden rights, and I guarantee at least 3 of them are going to make you wish someone had told you years ago. Some of these could literally change your legal status overnight. Others might put money back in your pocket that you've been overpaying for decades. Let's start with one that catches thousands of RV owners completely off guard every single year. Rule number 10. Your RV changes legal status the moment you turn the key. You're retired. You're finally seeing the country. That RV isn't just transportation anymore. It's become your weekend escape, maybe even your full-time residence. So naturally, you treat it like home. You park for the night, extend the awning, lock the door, and keep a loaded firearm within reach, exactly like you would in your own house. And most of the time, you're absolutely right to do that. When your RV is fully parked, hooked up to utilities, engine off, and functioning as a residence, many states treat it as your castle. Castle doctrine applies. A loaded firearm under your bed is perfectly legal in most jurisdictions.
You can't just keep a gun in your car just in case. You can only transport a gun to and from a place where you are allowed to have it.
A controversial topic, but it's a topic that people talk about a lot. Traveling with firearms on your RV.
That protects us as American citizens to be able to travel across state lines with a firearm.
When transporting a pistol in a vehicle, it must be unloaded and in a locked container.
You must be able to lawfully own a firearm in the state of your origin and then the state of your destination.
If you have a concealed carry permit from the state of Florida, that is not recognized in several states, many of them on the East Coast.
A defensive response to a threat outside your door falls fully within your rights. But here's where everything changes. The moment you turn that key, your castle transforms into a vehicle under the law. Completely different rules kick in. That same loaded shotgun better be locked up, inaccessible, and stored according to your state's transportation laws. Otherwise, you could face serious charges. Law enforcement absolutely checks for this. In multiple documented cases, gun owners have been charged not for what they did, but for when they did it. The determining factor was simply whether the RV was in motion, recently operated, or ready to drive. The rule is straightforward. If it's moving, treat it like a vehicle. If it's parked and powered down, treat it like your home. Don't let a technicality turn your road trip into a court date.
If you're going to carry a firearm that, number one, you're comfortable with and that you're proficient with and that you can carry all the time.
You may not legally store a gun inside of the glove compartment or utility console of the vehicle.
The firearm must be unloaded, locked up, and not accessible to the driver or a passenger.
If you're carrying a firearm, you have to be aware of the laws of whatever state or country you're traveling in.
Rule number 9. That old hunter safety card still works. Most folks tossed it in a drawer decades ago. A yellowed certificate from some dusty hunter safety course you took back when disco was still on the radio. You probably haven't thought about it since. But that old card might be the only paperwork you need to get a concealed carry permit today. A surprising number of states still accept state-approved hunter education as valid proof of firearms competency. Doesn't matter if it's from 1978. Doesn't matter if it was handwritten. If your name's on it and it came from a certified program, you may be able to skip the expensive CCW class, skip the range time, and bypass the entire training portion of the permit process. States like Wisconsin, Virginia, Idaho, Arizona, Oregon, and several others have it in writing. Hunter education counts. But not one of them is advertising it. Why? Because every time someone forgets, the state collects another $100 class fee, another processing charge, another taxpayer overpaying for training they already completed when they were 17. Before you sign up for another 4-hour lecture from someone half your age, call your state's licensing office. Ask them directly whether your hunter safety certificate qualifies for CCW training credit. That piece of paper in your file cabinet might carry more legal weight than you ever realized. Rule number 8, you cannot be rushed during gun purchases. Walk into most gun stores today and you'll notice the same pattern. Paperwork stacked high, background checks buzzing, employees moving fast to get you in and out. That's the modern pace, especially when they see someone older walk through the door. The pressure starts immediately. Just sign here, it's all standard. You done yet? What they won't tell you, what they'll never put on a sign, is that if you're over 60, federal law protects your right to take your time. Under the Americans with Disabilities Act, seniors have the right to reasonable accommodation during the firearms purchasing process. That includes extra time, help understanding forms, reading assistance, or clarification on what you're signing. This isn't optional. It's federally protected. Hearing loss, slower processing speed, vision issues. Needing help to fill out a Form 4473 is not a weakness. It's a protected status. If a store rushes you, pressures you, or treats you like a problem because you need 5 more minutes, they're breaking federal law. If someone's pushing you faster than you're comfortable with, you say one sentence: I'm requesting reasonable accommodation under federal disability law. Watch how fast the tone changes. The moment you invoke that right, the pressure stops and the law steps in behind you. Rule number 7. Senior gun discounts actually exist. Most gun owners over 60 have spent more money on ammo and permits than they care to admit. You've supported the Second Amendment longer than some younger activists have been alive. Some of the biggest gun rights organizations offer senior discounts and hope you never ask about them. The NRA offers something called a distinguished life membership. If you're 65 or older, you can lock in a lifetime membership for $500. The standard price is $1,500. That's a $1,000 difference just for having more birthdays.
Gun stores have seen a new trend in sales, with more older customers coming in for firearms.
Things are changing because everybody's taking the initiative to say, I don't want to be a victim. I want to have the right to protect myself.
Because local gun shops say the potential for these restrictions has led to an increase in gun sales.
The Second Amendment, it's your right to bear arms, and recently local gun stores have seen an increase in older clientele wanting to express that right.
So we feel maybe a little bit more vulnerable, so we need to build up our other resources.
Gun Owners of America, Second Amendment Foundation, and several others offer similar senior perks, but none of them advertise it loudly because full-price memberships are good business when folks don't ask questions. These memberships often include monthly magazines, training materials, product discounts, access to legal defense funds, and sometimes insurance options. Here's the catch. These organizations usually won't volunteer the discount unless you specifically bring it up. If you're over 60 and looking to join or renew, pick up the phone and ask directly about senior discounts on lifetime memberships. You've paid your dues. There's no reason to keep overpaying when the discount was baked into the system the whole time.
Especially with this location, we have a lot of retired people around here. People like to do it as like a retired hobby, extra time in their hand.
But I spoke to an area manager of a store. He says this past week they are seeing an even bigger spike than usual.
I used to go camping quite often and on my own, so I just felt a little more secure being able to defend myself if I needed to.
Generally, that's the number one thing people say when they want to buy it, such as a handgun, is for protection of themselves or their home.
Rule number 6. You might be hunting for free. Every year, thousands of seniors walk into sporting goods stores and pay full price for hunting licenses, tags, stamps, and permits. They fork over $100, sometimes more. In many states, they didn't have to pay a single dollar. In Florida, once you hit 65, your regular driver's license becomes your hunting and fishing license. No special application, no paperwork. Turkey tags, deer tags, the whole thing waived. You've earned it through age alone. In Georgia, if you were born before January 1st, 1961, you qualify for deeply reduced licenses or free ones depending on what you're applying for. Dozens of other states follow similar models with quiet exemptions and age-based perks buried in footnotes. Most licensing systems are built to charge first and answer questions later. If you don't know to ask, they're not going to stop the transaction to explain how you just overpaid. Before you pay for your next license, search your state's wildlife agency website for senior hunting exemptions. You might find out that the license you've been paying for year after year was already yours. Now we're getting into the top 5. These are the ones that could genuinely change your legal and financial situation starting today. Rule number 5. Most seniors overpay for permits. Every year, seniors walk into sheriff's offices and licensing bureaus ready to renew their concealed carry permits. They hand over the full amount without question, not because they have to, but because no one ever told them the price drops after a certain age. Louisiana has it in writing. If you're 65 or older, you pay exactly half. A 5-year permit that costs $125 for younger applicants drops to $62.50. A lifetime permit, normally costing $500, becomes $250 for seniors. Alabama rolled out lifetime pistol permits recently. Standard cost is $300, but if you're 60 or older, you pay $150. Same permit, same privileges, half the cost. Texas lowers renewal fees for seniors across the board, but you'd never know unless you read the fine print. These discounts exist. They're legal, they're active, but they're not advertised. Before you apply for or renew your carry permit, call your state's licensing office and ask directly about senior rates. Rule number 4. Born before 1961, you're already exempt. If you were born before January 1st, 1961, there's a good chance you're already exempt from mandatory hunter safety training. No test, no online course, no range day, just your birth date doing all the work. Georgia makes it crystal clear. Anyone born before 1961 is exempt. Texas, Arizona, Tennessee, and others follow the same model. They know you learned firearm safety the old-fashioned way. Before signing up for any hunter safety course, check your state's wildlife site. Look for the phrase, born before, and see what the cutoff is. If your birthday qualifies, you're done. That's your exemption. Rule number 3. Retired officers get nationwide carry. If you served as a law enforcement officer for at least 10 years and retired in good standing, you may already have one of the most powerful concealed carry privileges in the country. It's called LEOSA, the Law Enforcement Officer Safety Act.
Here's on the job, the tools that you can bring with you every day to work sometimes develop some sentimental value.
The law exempts certain active and retired law enforcement officers from local and state prohibitions on the carrying of concealed firearms.
If you are retired with 10 or more years of service, then you get to carry concealed in all 50 states.
In order to qualify under LEOSA, active law enforcement officers must meet several important requirements.
Retired police officers are allowed, under federal law, to carry a concealed firearm in many circumstances.
Passed in 2004, it gives qualified retired officers the ability to carry a concealed firearm in all 50 states, regardless of local permit requirements. If you live somewhere like New Jersey or California, where regular citizens often can't get permits at all, LEOSA overrides that. It's federal protection. States cannot deny it. A large number of retired officers never apply, not because they're disqualified, but because they don't know it exists. Contact your former department's HR or training division about obtaining LEOSA credentials.
They must have separated from service in good standing and served as a law enforcement officer for an aggregate of 10 years.
LEOSA allows retired officers to carry concealed in most locations.
The LEOSA Reform Act will allow these officers to carry a concealed firearm in the same manner many licensed citizens carry a firearm.
Officers, man, they become accustomed to it. They have kind of an affinity for it. I mean, when they retire, we don't reissue those guns to anybody. Every officer gets a brand new firearm.
The bill also reduces the frequency that qualified retired law enforcement officers are required to meet certain qualification standards.
Even if local or state law restricts or prohibits concealed carry.
Rule number 2. Congress quietly blocked a gun ban. Back in 2016, a regulation was rolled out that would have labeled thousands of Social Security recipients as mentally unfit to own firearms. Not because they had violent histories, but because someone else helped manage their checkbook. If you needed a representative payee to handle your benefits, something as common as a child helping with monthly bills, you were about to be flagged and added to the FBI's prohibited persons list. No hearing, no warning, no due process. In February 2017, Congress voted to repeal the rule before it took full effect. Most gun owners have no idea it happened. The government cannot strip away Second Amendment rights just because you need help managing money. That precedent is now set. But stay alert. Rules like this don't stay dead forever. Rule number 1. Age alone does not take your guns. There is no age limit on the Second Amendment. No line in the Constitution that says your rights expire at 70. Federal law is crystal clear. The only way someone loses gun rights over mental health is if they are formally adjudicated as mentally incompetent by a court of law. That's not a doctor's note. That's not a diagnosis. That's not a family member saying you forget things now. That is a legal process with a judge, an actual due process. Thousands of seniors voluntarily give up their rights every year, not because the law took them away, but because they were made to believe they no longer qualified. If no judge has ruled you incompetent, your rights are intact. Your age isn't a disqualifier, it's a qualifier. You've lived long enough to know what rights really mean. That's it for today, folks. See you in the next video.